Council, we've got a number of things going on today, as I understand it. And I just wanted to spend a moment or so to make sure that I understand where we are. So first of all, we've got a motion. I had set this matter on for oral argument related to the effectively a motion or petition for removal of personal representative. There was then a motion to shorten time as it relates to a motion to continue this matter. Does that generally sound right to both of you, that that's what we're here on today?
That would be correct, Your Honor. I would flip the order though of.
I'm not asking for the order. I'm just asking for, does that sound like the three motions? So a motion to shorten, a motion to continue, and argument on the petition for removal. Does that sound correct?
Yes.
Yes.
Okay. So I want to first take up the motion to shorten time. I am going to find that I reviewed the objections and the motion itself. I'm generally inclined to grant the motion to shorten time on the motion to continue. Mr. Ron, do you want to make your record as to objection on that?
Yes. So the motion to shorten time was filed on April 3rd and served on April 3rd. Under Court Rule 6D, a motion needs to be 5 days notice. And so we aren't even timely with being able to have the motion to shorten time. So my position would be is he didn't timely file that 5 days before the hearing. And second, I would still continue with the argument that this is a hearing that's set for March 25th. And so it's extremely late because it would have been due to have been filed on March 18th. And so by either standard of April 8th or March 25th, the motion to shorten time is late.
Can you identify to the court any prejudice by the motion to shorten time itself?
The prejudice, I follow with what you're saying. The prejudice to shorten the time. Well, it would shorten his time period for when he had to file his motion to continue. And so, I mean, we're talking about a hearing that was set for March 25th. That would have had a motion to continue would have needed to be timely filed on March 18th. So you're retroactively going back and you're going back to try to retroactively bring in a motion to continue that is 3 weeks late. So for one, that would be prejudicial to me because I wouldn't have had adequate time to respond to that.
I'm not clear about that because I think so you're prejudicial because your perspective is you have not had a chance to substantively respond to the motion to continue. Is that right?
Well, this is the other argument, Your Honor, and this goes back to, I guess, mediation again. So in order to figure out what the family support award would be, we need the court's direction as to who the PR is going to be.
I'm not possible, so we're going to get to that in a minute.
But I guess what I'm saying, though, Your Honor, is that we also would need to know the distribution scheme of the estate, which would then need to be a decision on this petition.
Okay, so again, I'm not hearing prejudice on the motion to shorten time related to the motion to continue. I do think that the motion to shorten time, I am going to go ahead and grant that. I am going to hear argument substantively on the motion to continue. And then if I deny that, I will hear argument on the actual removal issue. So I will go ahead and grant that. You can reduce it to a written order later if you like. So Mr. McCreary, with that in mind, go ahead and argue your motion to continue.
Thank you, Your Honor. And when I filed the second motion to continue last Wednesday, I added some language to that one that included not just the motion to continue, but a motion to defer the ruling. And it's the same thing, but when spoken, continuance just sounds like we're on a criminal docket and we're going to fill out a slip for a hearing next week. But really, what I'm talking about is deferring the ruling until after the mediation. That's why I brought it in the first place and the timing that I brought it. So, my motion to continue is asking the court to defer its ruling on the issue that is the substantive issue today. And I think one of the things that goes into that really is the mediation. And the family allowance matter, the 061 case, is going to mediation. That order's just been signed. So there's no need to disrupt the status quo and increase the costs in the estate to get a new PR just to find out that we were able to resolve this in mediation or arbitration. Um, it, it it's sort of, well, it just strikes me as a waste of time. And so that's why we're asking for that continuance slash deferral. Um, I also presented to the court in my affidavit some concerning issues that I think counsel has sort of brought on in this case, which is an intentional and purposeful measure of delay. When you have a notice of unavailability of counsel that picks out a couple of days in a month here, a couple of days in a month there, and then maybe an extended 2-week period or so in June, and then say, gosh, I can't mediate this until October, that starts to get into the realm of CR11 in terms of purposeful delay of the case, and it explains to the court where counsel is coming from on this. If that wasn't clear enough before.
I understand that. I am going to get to that. I'm not going to find that there. I don't think I've got enough to get close to a Rule 11 issue, but I do want. I will ask about substantively about that. I understand the notice of unavailability issue, and I will ask a little bit about that in a moment. But I don't think I want to wade into a Rule 11 issue here.
Okay. And I was likening it to that, but the concern that also comes up in that letter that I submitted with my declaration from counsel is he indicates that he needs time in order to prepare for a mediation. And it's been really clear in the last couple of weeks of being on this docket, counsel was ready to argue this matter to a conclusion in that moment, but then needs until October to prepare for a mediation, which requires less preparation than this docket today. So, we're asking for a continuance and our concern and deferral of the ruling. And our concern is that they just want, at this point, they want to drag things out in the mediation process so that they can argue, hey, we need a new personal representative in the intermediate time because it's going to take so long to get to that mediation. That's not fair dealing. That's not fair practice in terms of this issue. A mediation is going to happen pretty quickly. Judge Warning is available, and we've agreed on Judge Warning as a mediator. We get that to him. Hopefully, we can resolve our differences in this case. If we can't, the statute pushes us to arbitration. If that doesn't resolve it, then we're in a realm where we're dealing with really dealing with the long run of the case. My client has a bond. So counsel's client's interest is covered with the bond, and there's no meaningful allegation that she's done anything wrong under the statute. 11 RCW 1128-250 lists out why you would choose to revoke letters testamentary, and we don't have anything that satisfies what's listed in 1128-250. So there's no prejudice to a deferral of this ruling so that we can attempt to use dispute resolution in the TEDRA statute as it's intended to try to just get this case taken care of.
Thank you, Mr. Ron. Your response?
Yeah. Okay. So I just think it's important to note the whole reason we're here today was to hear oral argument. The basis for why his client's letters need to be revoked is failure to give notice. Your Honor, I'm queuing.
Hang on. I want to get to the heart of this issue. So let me tell you where I'm at. I've reviewed everything in detail. We've now heard this case multiple weeks. The concerns, as I understand it, over spousal support, family support, what monies go to whom, what heirs are gonna take and how they're gonna take it. All of that, it seems to me, is going to be determined by Judge Warren in a mediation. Or at least a large chunk of those issues are gonna get resolved by Judge Warren. So the question in my mind is, why remove a personal representative if Judge Warning is going to wade through all those issues anyway? Am I missing something here?
Yes.
What?
The statutes clearly, Your Honor, in their petition, if you go into Odyssey and you go into the original petition that they filed, they acknowledge that Tabitha Dalzing is the legal spouse of the decedent. And then they turn around and they lie to the court about the distribution of the estate.
Wait, when did they lie about the distribution in the estate?
It says it on page 3 of their petition.
They admitted they lied?
Your Honor, if it says it's an estranged spouse, and under the intestate statute, if you are a spouse under RCW 11-04015, a spouse is entitled to 75% of the separate property. And they say 25% of the estate goes to the four sisters.
Okay, but
Your Honor, what I'm saying though is, I'm fine with going to mediation and figuring out the family support. What I'm trying to say though is, my client needs to have her statutory rights vested, and the delay to October is, unfortunately, I'm starting a new law practice. I'm gonna need 2.5 to 3 months to probably get it formed and to work on that. And I have other obligations to clients. I'm gonna take some time to prep, and unfortunately, I don't feel comfortable going and representing my client, Ms. Dalzing, until October, given my caseload that I already have and forming a new practice. It's not like I'm intentionally trying to.
I'm not getting into that. That's not my concern. We'll take that up at the very end if there's time. What I'm unclear about is why, if we're talking about whether or not Tabitha Dalsing gets 75% or some other portion thereof, why is that not before Judge Warning? How is that not before Judge Warning?
Because this is a statutory right, and Mr. McCreary in his notice for mediation only asked to go.
How is that not currently before Judge Warning?
That's in the family support issue. That's extra on top of what the statute already entitles her as the beneficiary of the estate of Leon Dalsing. And so what we're wanting the court to rule on today is failure to give notice for the petition, which would revoke her letter. She got appointed by defective notice. The court can revoke letters on that basis. It has nothing to do with 250. It's just failure to give notice. And we want the court to have a finding that we've got a vested spouse with 75% of the estate. That is not subject to mediation. That's just what the statute says.
So, okay, then. So let me turn back to Mr. McCreary. Mr. McCreary, is the personal representative currently disputing that Ms. Tabitha Dalsing gets 75% of the decedent's estate? Is that under dispute?
No, and I'll qualify it this way because I think this is important to understand. As between the statutory heirs, we have a determination of separate and community property. Our position is that it's all separate property. They parted ways 17 years ago, filed a divorce, and then just kind of let it go. And the land that is the primary asset is family land that came from Mr. Dalsing's parents and his sisters. And the other component of this, which means that if it's all separate property, Tabitha Dalsing gets 75% of the exempt, I guess, property, and the siblings get 25% shared among them. What's not accounted for is if there are claims against the basic estate. And so we have a woman named Karen Head who was, at a minimum, Mr. Dalsing's significant other. She's potentially his partner in a committed intimate relationship. They attempted to berate her in their petition, and her claim is before that distribution occurs. So to decide now that we're going to hand the money out according to this scheme doesn't fly when there are potential claims that could reduce the amount of money that's there. And I understand there's a difference between the amount of money versus the percentages to be established, but I'm not arguing that the statute doesn't leave my clients at 25% for the siblings. That's not something that, like you say, really doesn't even need to be decided at this point, because we're going to mediation on the issues, on who gets what. But
So let me follow up again so Mr. Grant. So hypothetically, let's say I grant the petition to remove, we hear argument today, and I grant a petition to remove. And then, I think you had an alternative, I don't recall who it was at the moment, but you had a professional alternative, personal representative. So presumably that personal representative is not going to do much between now and October until after there is a mediation on the other issues. So why would it not, as a matter of judicial efficiency and efficacy, what's the harm in deferring this decision?
Your Honor, I have represented multiple PRs and estates. This is what would happen if there was a professional PR. They're going to marshal the assets. They're going to sell these properties. There's going to be a stockpile of cash then that would then be subject for mediation. And then we get to go to the table and we can say, this is what Tabitha Dalsing would be entitled to with 75%. This is what's subject to the family support award. We can then figure out how the cash is going to be split up. I'm more than happy to go to mediation and negotiate with a pile of cash to negotiate over. And they can then work on finding the tax returns. And then we can figure out at the end of this, okay, this is what Tabitha Dalsing is entitled to. This is what Mr. McCreary's client is entitled to, along with the other three sisters. I am more than happy to do that. But the reason why we want a professional is because Mr. McCreary has filed multiple things in different hats, not only representing Barbara Rogan as the PR of the estate, he's filed a creditor claim on her behalf. He's filed a declaration on 3 other beneficiaries' behalf, and that's a breach of fiduciary duty and impartiality, which I've briefed in one of my earlier memorandums of law. He's represented multiple different people in this party. And if you're the shareholder of a company.
Well, hang on. Then if that's your central argument, is that Mr. McCreary has a conflict between representing one of the creditors and representing a PR, then isn't the proper motion here to bring a disqualification of Mr. McCreary in one of those 2 capacities? Why does that require a change of the personal representative?
Because her letters are defective to begin with, Your Honor, by failing to give notice on the 10-day statute. That is what the basis of why her letters need to be revoked. And then we're up for play on who should get their letters. Ms. Rogan wants to put her name back in the hat to get her letters. There's the breach of fiduciary duty by impartiality. And that is why there's the benefit of a professional PR that would be looking out for the benefit of all beneficiaries. Back to my original point, though, Your Honor, if you have a 75% ownership control of a company, don't you feel that as the majority controller, you should be able to say who I want to be my CEO or president of the company?
I'm not sure that that's relevant. I think the statutory language is relevant. I don't know that what one's wishes are is necessarily relevant. Mr. McCreary, what about this issue of the lack of proper notice to Ms. Dalsing when this?
So my reading and interpretation of 1128-120 has always been that once the 40 days passes, it's kind of a free-for-all at that point. And Ms. Dalsing, who's a felon, didn't qualify to be PR anyway, but my argument there is that the 40 days passed, and so she basically waived her right to notice and right to participate as the PR. I would also point out that we attempted notice, but we also put in our petition that she's transient. We had what we thought was a good address that turned out not to be. And so there's no prejudice in terms of the appointment of my client as the PR.
Your
She
Honor?
hasn't she hasn't acted in a way that satisfies 1128-250 in terms of some kind of self-dealing or anything. Filing a creditor's claim in an abundance of caution, because we don't know if we're going to win or lose in this matter, then we're going to come up against a potentially a personal representative who is getting direction from Ms. Dalsing. Maybe she decides not to pay my client back for all the money that she's come out of pocket just to try and respectfully take care of her brother's estate. I mean, if you look at what the creditor's claim includes, it really is basically expenses of the estate. There's no evidence of any self-dealing. I would also point out that the duties of a personal representative under 1148-010 are to rapidly and as quickly as possible basically wrap these matters up, which involves, in some instances, I mean, personal representatives need to defend basically what the statute says. And here we have multiple siblings who are in the same position, and essentially my client would be prepared to sell the real estate and pay the siblings if that's where this winds up. That stepping in and allowing them to be heard isn't a conflict of interest. It's just furthering what the law says, and letting the court know where those parties are at in this process.
Okay, so I appreciate that, Mr. Ryan. I'll ask you a question, then you can, any final thoughts? As I review RCW 1128-030, if the court finds such spouse and or domestic partner to be other qualified, but if such surviving spouse or surviving domestic partner do not make application within the 40 days immediately following the death of the deceased person, he or she shall consider as having waived his or her right to administer upon such community property. So what did Tabitha Dalsing do to preserve her rights within the 40-day window?
So, Your Honor, I believe that just means it's waiving the right to serve, not waiving the right to notice. If you look at RCW 1128-131, it says when a petition for general letters of administration, I'm going to paraphrase, if there is a surviving spouse and anyone other than the surviving spouse petitions the court to serve, they are entitled to give they are supposed to give the surviving spouse 10 days notice before the hearing. Mr. McCreary got his client appointed by ex parte filing. So not only did they not have the hearing, but number two, they never gave my client notice, which is what the 10-day requirement is.
And I submit that that was waived.
Hang on, Mr. McCreary. What's the statute you just cited from, Mr.?
Yes, Your Honor. It's 1128-131. It's just waiving notice. Or it's not waiving notice. It's waiving the right to serve. Excuse me.
Either of you have any case law on that?
No,
Not at this point.
Very well established that that's the rule.
I would just say that that's if she's in the race to be PR, not when she's checked out of the race to be PR. And the statute checks her out after 40 days.
So the second half of 1128-030 states as follows: if any person other than the surviving spouse or surviving domestic partner makes application of letters testamentary on such property prior to the expiration of 40 days, then the court, before making any such appointment, shall require notice of application given to the said surviving spouse. Unless they've shown satisfaction to the court, there is no surviving spouse. So the notice, as I read that second sentence, the notice is clearly tied to prior to the expiration of the 40 days. Again, in plain language, if any person other than the surviving spouse or surviving partner makes application for letters prior to the expiration of 40 days, then the court shall require notice of the application to be given to the surviving spouse. I then turn over to RCW 1128-131. And it says when a petition is filed, matter may be held provided that if there's a surviving spouse, the petition is presented by anyone other than the surviving spouse. Notice to the surviving spouse shall be given of the time and place of such hearing at least 10 days before the hearing, unless the surviving spouse shall waive. But I think that is, I read that to say only if under 1128.030, they have not waived their right prior to the expiration of 40 days. So unless there's a statute or case law suggesting otherwise, I think the only way to read 1128.131 is to require notice prior to the expiration. Because that is in conformity with reading, I think 128.030 and 128.131 have to be read together. I don't think I can read them in a way to nullify for 131 to nullify 030. I don't think as a judicial officer I can read one statute as in a way to nullify the other statute. Mr. Ron, last word.
You can, Your Honor. That says it's community property. We're dealing with separate property. A surviving spouse or surviving domestic partner shall be entitled to administer upon the community property. It's only talking about community property. It doesn't say separate property. And the statute, the header of the section is community property who entitled to letters. We're dealing with a separate property estate. Then we're getting into the general letters, which would be 131.
That results in a nonsensical situation where the spouse is somehow now not entitled to administer over their own community property interest, but somehow has authority over separate property. I don't think that's a fair reading of this combination of statutes.
Statute only says community property in 30. It's completely silent to separate property.
Mr. Ron, I think you're probably correct about that. So I think you are correct that 1128.030 is specifically referring to community property in the second paragraph that I read. And that would then suggest that 131 is not read to nullify 030, and therefore there would have to be 10 days notice prior to the hearing. That didn't occur here. So I'm still not sure from a prudential perspective why, and from an efficiency perspective with a bond in place, why this is turning into such an argument. I don't actually hear any argument really over who's going to get what, but apparently there is. Mr. McCreary, do you have any other thoughts substantively on the removal? I think my interpretation of 131 is I have to remove because there was no 10-day notice.
Well, I would submit that the waiver is still there. And in any event, the court has the authority under the TEDRA statute, the plenary powers that you're given to decide what you want to do with this, regardless of that notice issue. We haven't distributed the estate. We haven't run off sort of with the authority as personal representative and done anything that's some kind of irreversible harm or something. So the court's really in the same position to just allow things with a bond to stay in place.
Yeah, and that's what I'm referring to, Mr. Ron. I don't know why I'm not. It's not my job to tell you or your client what to do. I don't understand what the fight here is about, quite frankly, because I don't. The issues that are before Judge Warning has full ability to resolve, and I'm still unclear why there needs to be, if there's a bond in place, why the personal representative needs to be replaced from a prudential. I recognize you have an argument that, well, you want to, your client, not you personally, but your client somehow wants to have their pick of a personal representative. Okay, but a professional representative, I don't think is going to do much different than what is going to play out over the next 6 months if the personal representative remains. But again, that's neither here nor there. I will go ahead, and I think I have no choice because of that notice issue, but to remove the personal representative and then appoint a personal representative that that has the ability under the statute, which Ms. Dalzing cannot do, so she is looking for an alternative personal representative. That's my ruling. I don't understand this. This to me is not that hard to figure out, but apparently it's being made harder for reasons that I'm not aware of. I do think, Mr. Ron, I think it is difficult to understand how the mediation or the arbitration that in the other matter cannot happen within 6 months. I am perplexed by that, but I'm not going to find Rule 11 sanctions because that's not before me. I don't think there is Rule 11 sanctions, but it doesn't make any sense given the massive amount of pleadings that have been briefed over the last 3 to 4 weeks on this matter that it can't get before Judge Warning much quicker. So that's just some thoughts from the bench. I'm not going to tell you what to do, but I'm not understanding why I can't get to Judge Warning faster.
And Your Honor, I would just say that the statute regarding the mediation allows that if we can't agree on a time, that we will bring it back before the court for determination.
I expect that's going to be the case.
As do I.
So, Mr. Ron, I will go ahead, and I don't think I have any choice but to remove the guardian because of the lack of notice under 131. Or I'm sorry, the personal representative. I was thinking we're on the guardian docket, but the personal representative under 131. I will go ahead and sign an order to that effect when it's presented. I would like you, I don't want to wait on this. I think that there's a lot of issues floating around. So I'd like you both to work on an order and get it to me no later than Friday noon. I want to get this order in this week. Do you have any questions about that?
Your Honor, I want to clarify there was just a decision then removing Ms. Rogan as the personal representative. Does that mean the requested professional Sherry White with legal counsel of Meredith Long is now appointed?
I'm gonna reserve on that issue and see. I really want you two to work this out. I'll make a decision on that if I have to, but I really think that you two need to work it out, who you want. If you can't do it by stipulation, then bring it back.
May I have permission to
reserve on that issue? I'm not awarding any attorney's fees on this.
Okay, do I have permission to talk to Mr. McCreary for a moment, Your Honor? This is not, I just was gonna say, Mr. McCreary, I can call you in 10 minutes after the docket. I just want to go get a drink of water and I'll give you a call.
Certainly, we both have phones. I have no problem with that.
Okay.
One of the things that goes with this is my client's bond and so forth.
Yeah, we'll vacate the bond as part of that. I'm not going to require a bond if she's no longer the personal representative. I saw that in your pleading, Mr. McCreary. Anything else that either of you need for the form of an order?
I don't think so. I'm certain the course of preparing an order is going to give rise to a few issues, but we will do our best to present something.
You can civil docket. If I'm not done with my civil docket by 4 o'clock, you're welcome to jump back on. And if you can't, we'll get it done today. I get it done quickly because this seems to me, if I don't do it quickly, it's going to turn into a festering issue, and I don't want that to happen. I want clarity in the record for both of you, for Judge Warning, for any motions to revise. I don't want the issue sitting out there.
Very good. Thank you.
Have a good day.
Have a wonderful day.